I want everyone to know that that is actually a false notion. Someone's ability to pay child support is separate and apart from their ability to be a good parent. If you go into these in recommending counties and disparage the other party and make it about your dislike for the other party and not how it's impacting the children, it's likely going to come back to bite you.
From violated court orders to custody fights to hidden income, attorney Crista Haynes and her office manager Jenny Palmer have spent 8 years on the front lines of California family law. 2 women, 1 mission, pulling back the curtain on the mistakes that cost families everything. The pitfalls inside the courtroom nobody warns you about. Their mission, giving every parent and every child the voice and the protection they deserve.
People's disregard for anybody's feelings or time, for that matter.
Your attorney cannot protect you if they don't have all of the information. I don't care what the bad information is, it is better to be upfront with that information so that we can work around it. On today's show, we are going to have my office manager, Jenny Palmer, with us, and I'm so glad that you could come to talk about some of the client pitfalls and things that we want to give tips and tricks to those who listen and who are following along with each of our shows. And so I'm so glad that you were able to visit the show today.
I'm very happy to be here and be able to help.
So you have been a part of the Haynes Law Firm team now for approximately 8 years. Time has definitely flown by. When you came to the Haynes Law Firm, had you had any previous law firm experience?
No law firm experience at all. I was just a bar manager.
Okay. And so would you say that when you came to work at the law firm that you were able to experience a lot of new things along our journey as the Haynes Law Firm?
Oh, most definitely. It was a teaching day every day.
All right. And because we do predominantly family law and juvenile dependency, what are some of the things that really have surprised you about the law while working at the Haynes Law Firm?
People's disregard for court orders, people's disregard for anybody's feelings or time, for that matter. But in general, just, I would say, the amount of expectations there are for everybody, but people just don't see them for their case syndrome sometimes. Okay. And when you are referring to violations of court orders, how often would you say that we get phone calls from our clients wondering what to do because the opposing party has broken that court order that we just received or that has been placed for years to come? Daily. And what are some of the types of violations that you hear of on a day-to-day basis? Pickup drop-offs, not showing up for those, taking money out of accounts when they shouldn't, people going to the school when they're not supposed to. Okay. And when you hear these types of concerns from potential clients as well as our own clients, what is your go-to answer in an effort to be able to mend the conflict before the necessity of going to court? Have you tried working it out with the other party? Have you guys tried to come to an agreement on certain things? Have you asked them why they did what they did, as well as try to communicate either with their attorney about the situation before having to sometimes, in the sense, do an unnecessary court involvement when it could have been figured out? You bring up a really good point. There is a rule. It's a rule of court, as well as it's codified in almost every single county's local rules that requires parties to meet and confer prior to filing any request for order. But more importantly, it also demands that parties meet and confer with one another to try to smooth things out and to come to an agreement before involving the court. So when you receive these types of phone calls, it is the best advice to tell people and anyone out there listening, if you are experiencing these types of violations, whether or not it's because someone's refusing to meet you at the pickup and drop-off location, whether someone is withholding your child, whether someone is attending court, attending school functions or medical functions that they don't have the right to attend, whether or not they haven't been paying support or the like,
it's always a wonderful idea to say, hey, have you reached out to them to see if you can come to an agreement? Typically, the answer to that is yes, that's why we're here. If they have an attorney, have you tried to reach out to their attorney to get them involved to see if there can be an amicable resolution rather than having to go to court? And what is most important, I think, for people listening is that you want to make sure that you have some sort of recorded mechanism to be able to show as documentary proof that you've done this so that you can avoid any unnecessary attorney's fees or sanctions awards against you for failing to do so. So you want to write letters. You want to use your co-parenting apps such as Talking Parents, App Close, and or Our Family Wizard to be able to have a record that says you've been trying to work out this, and you want to reach out to that opposing counsel if one exists to be able to say, look, here's a clear violation. I don't want to go in on a contempt order. I don't really want to go in on an ex parte. But if your client can't straighten up or get in line, then I have no other option. And when that occurs, then you're safe to file if there's still no resolution. How often do you say that you get phone calls regarding support not being paid?
I would say probably about maybe 2 to 3 times a week.
And what are the typical complaints that you get with regards to support?
They're not paying what they're supposed to be. They have decided they're going to withhold the child if it's not paid, or they're going to withhold the child so that they don't have to pay you.
So I think that one of the misnomers in the area of family law is that if you aren't seeing the child, then you have to pay more. Or if you are not paying support, that you're not entitled to see your children. I want everyone to know that that is actually a false notion. And realistically, they are 2 separate entities and judges will treat them as such, meaning that if you call in and you say he hasn't paid support in 5 years and he's demanding to have more time with the children, I want to fight this modification because he hasn't supported them. That isn't going to be a justification for you to actually be able to not win over the request of a modification. Someone's ability to pay child support is separate and apart from their ability to be a good parent. With your statements with regards to them not paying what they believe that they should, can you get a little bit more in detail with regards to what some of those complaints are from the people that you talk to?
So some would be that I know that he makes more than what he's saying, so I believe I'm entitled to more. Also that he gets overtime. Why can't I get more money if he's getting overtime? As we know, overtime is not always guaranteed. So it's hard to put that into their minds that you can't just use that. People, I have expenses for other children and I need more money from this person for this child.
Okay. And so how often would you say you get those types of complaints?
Not too often. Sometimes they're already in relationships, so those relationships are taking care of that other child. But there are a few that they believe that they can get support here, and they can't really get it in that other aspect, so they want to get it from this person.
And would you say that the complainants that are making these statements, the opposing party work W-2 jobs, or are they more self-employed or contractors? What type of employees are the opposing parties typically in these situations?
I would say it's between a W-2 and a self-employed employee.
And with regards to the opposing party who is self-employed, what are some of the complaints that you receive with regards to pinning down their specific income?
We need their profits and losses to be able to see that. But a lot of the times they're getting cash. And so they like to hide certain aspects of their income. So it's hard to be able to show exactly what they make and say, look, we know you make this, but you don't claim it.
Right. Yeah. I think that cash in general in the family law realm is probably one of the biggest pitfalls in general. One, if you are the payor, don't pay in cash because there's not going to be a definitive record that a cash payment has been made and or received. Two, cash as a asset in a divorce is always a point of contention, because someone is going to say that there was $50,000 in the safe. And when we get the declarations of disclosure, we now say that there's $10,000, and there's no definitive way for us to be able to prove that that $40,000 additional dollars ever existed or wasn't spent during the marriage, and thus would have just been a community expense. And so if you do have cash, you want to make sure there is at least some sort of record keeping or some sort of mechanism that's put in place. Record it, take pictures of it near the time of separation, or if you really don't trust the other side, make sure that you have access to that cash and that you put it somewhere for safekeeping so that it can be divided equally. This is also true of a community property business or even a separate property business that receives cash as a way of payment for services or products received, because more often than not, those businesses do not actually record it for tax purposes. And so that can be very, very difficult. So if you are the spouse that either is the out spouse to a community property business, or your spouse owns a business, you want to make sure that you're making note of this for your taxes if you can see a separation in the future, because you're going to be precluded from saying that cash consistently was used for community debts and for community obligations if there's no record of it. And more importantly, if you have signed previous tax returns that said that there were no cash income, it's going to be very difficult in the future to say, you know, that your opposing party made $50,000 in cash. There's no record of it in the actual books. There's no record of it in the profit and loss. But most importantly and most damaging is that you signed tax returns stating that $50,000 in cash did not come in any given year. So you want to be cognizant about that, even if you are in a healthy relationship, that at some point it could come back to bite you. Again, this is equally important in another realm. Another realm is that for cash that comes in and the form of rental income for community or separate property that is not actually deposited into the bank to make the mortgage payment, you can completely take away your ability to say that your separate property rental, a property that you owned prior to marriage, and that completely and utterly funds itself by having a tenant in there the entire time of your marriage. Because if you don't deposit that cash and you make the payment out of your bank account, which is a community property asset during the marriage, the community then therefore gains an interest. So one of the largest pitfalls that I think that I have seen in all of my years as being a lawyer, and I know that I hear it consistently from you and the other girls in the office, is that one side or the other is either trying to fight that the cash didn't come in, or that cash didn't exist, or someone is trying to say, no, I definitively know that cash existed. What are some of the other pitfalls that you think that other potential clients or people who are going through a family law matter should be knowledgeable about?
Disparaging comments towards the other party or about the other party, not even just to the child, but to anybody around them. Playing tit for tat. Just because he's being negative or she's being negative doesn't mean that you have the right to either. Going into mediation to just bash the other person instead of being child-centric and focusing on what's in the best interest of your child.
Yeah, I think that one of the things that is kind of a repetitive monologue that I give to our clients, and I know I've heard everyone in the office in mediation prep for our clients, is to say, look, I know that you want to get your point across, and I empathize with you that your ex is kind of a jerk. I mean, you wouldn't be getting divorced or you wouldn't be separating from them if they were the greatest person in the entire world. So we know that there are issues between you two. But going into mediation, especially in recommending counties such as San Bernardino or Riverside, and what that means is that in San Bernardino and Riverside, when you go into mediation, the mediation therapist, the counselor, the mediator themselves are going to write a report that summarizes what occurred during the mediation, what the pitfalls are, what the strengths are of each household, and their actual recommendations for custody and visitation. So if you go into these in recommending counties and disparage the other party and make it about your dislike for the other party and not how it's impacting the children, it's likely going to come back to bite you in the recommendations, because if the other side can focus on what's in the best interest of the child without disparaging you or making this a tit for tat, and they can make it child-centric by tweaking their words, they're going to look like the much more workable parent, the parent that isn't going to try to interfere with the other parent's parenting time or the relationship with the children. And so it's exceedingly important to remember that if your issue is that your ex is lazy and can't get the children up on time to get them to school, that's a valid concern, but you need to reword those statements to say, it is inappropriate for dad to have parenting time during the school week because there is a pattern that the child has not made it to school on time, has been unprepared, has forgotten homework, has gone to school without eating breakfast in the morning, or has missed repetitive days at school while in my ex's custody, and that's impacted our child's education. They've had multiple tardies. They're about to have a truancy letter because of the time that they spend at their dad's. That gets across the same point, but you have said it in a manner that is going to have an impact that says, oh, this child really shouldn't be with dad during this time. And it ultimately says the same thing. Dad is kind of lazy, or dad is incapable of doing what needs to be done for the child on an educational basis. So I think that a large pitfall, like you said, is not knowing how to turn your statements around into making them child-centric instead of being so focused on getting their point across that the other side is bad and they are good. So with that in mind, what are some of the other statements that we receive that we can help today on today's show turn those statements into child-centric rather than statements that are simply trying to get their point across?
Oh man, a lot of them are they want to say that the other party is manipulative or a narcissist. And so I feel like we've dealt with that probably in every other case that we've had. And so we have to help them turn it into showing it, as you said, child-centric. And it's their behavior in general, or they don't show up, but putting it in a way that shows like their kid counts on them and they can't provide what they need at this time.
Right. So rather than making the statements that are angry in general, or they're disparaging or disrespectful remarks, coming out right and saying, I think that my ex is a narcissist, is never going to come across as being a good platform to build upon for co-parenting purposes. So rather than using those languages, even if they are correct, you want to focus on the behavior that makes you think that they're a narcissist. So is it that they are gaslighting both you and the children? Are they making statements to the children at the end of every single visitation that's making promises that are against the court orders before having had that conversation with you so that you look like the bad guy? An example of this is that, hey, we're going to go on a cruise. And we're going to go on a cruise, a Disney cruise. And it's going to be so much fun. We're going to meet all the characters and it's going to be so fun. But you just have to tell mommy that you want to go to the Bahamas and that we have to get you a passport. Doesn't getting a passport sound fantastic? This is a form of child abuse because you are promising something to a child and you are turning the child into the mechanism that's going to propel mommy to either be the bad person because she doesn't agree that dad should take her on this Disney cruise that's international, or that the cruise is going to interfere with school, or that there is no time within their court orders that allows for dad to take this 7, 10, 14-day cruise. You can use examples like that to show that he is using the child child as a messenger, that he's manipulating the situation by using the child, and that's damaging to the child, and it puts you into a position of either being the bad guy or giving in to dad, even though dad is violating the court order. So it's taking situations like that is to say that he is a narcissist or he's abusive, but not coming out right and saying that and showcasing how it's affecting the child. So we'll do one more example of things that people say specifically from mediation standpoint that can be damaging to them. So what's another comment that we regularly see?
People living in the past, they want to bring up something from 3 years ago when it plays no part into what is currently happening today. So dad threw a shoe at me 3 years ago.
Yeah, this is typically used as a mechanism to be able to gain a advantage in the situation. So things had been working swimmingly for the last 3 years. They broke up. They were able to work out an amicable solution. And now somebody wants something differently. And what I mean by that is that maybe dad wants to move out of state, or maybe mom wants to move out of state, or someone has a job that's going to interfere with their schedule and they need to completely change the schedule. With something like that, typically we see everything that happened during the relationship that led up to the breakup or the divorce or the separation, really trying to tell people that has some bearing, but is a lot less weighted than what has been occurring for the last 3 years. Someone having thrown a shoe at you in the past, or someone had called you names in the past that led to the breakup, but you have otherwise amicably worked together for the last 3 years, isn't going to have the same weight. And so you really have to walk people through and say, okay, you're not going to win because he threw a shoe at you 3 years ago. Let's actually focus on the factors that the courts look at as it pertains to this move away request under La Mouche, or this change of custody, and whether or not there's an actual significant change of circumstance that would warrant the change. But most importantly, under a move away, under change of custody, under a change of child custody for legal purposes, you really want to focus on everything that's going to propel you forward and not necessarily what's going to make the other person look negative, especially if it's only historical things that can do so. If your child's life is here and your child has engaging friendships, they're involved in the community, they're doing very well in school, or they have a really, really excellent extracurricular activity that they're involved in, you focus on that and focus on how the modification, whether or not it's a move away or a change in custody or visitation, would impact the child. You always, always, always bring back your justification and your reasoning for what your request is as to the modification, your modification or your objection to it. How is it going to impact the child, and which parent is going to best be able to provide the best environment for that child? So now turning our attention away from maybe just the phone calls and the mediation prep, what are some of the other things with regards to forms or declarations that you think that individuals who helped themselves or represented themselves prior to our involvement have kind of created their own pitfalls? What are some of the things that you see in those two areas?
Not being honest of income or how they spend their money. They want to try to say that they are spending more than what they do, but in reality, that's going to hurt your case because you're living outside your means. Filling out a detailed declaration and giving us the specifics of what they truly want or why it's in the best interest of the child. The full background of events, people will give us part of the story, but leave out the things that are the most important.
Yeah, I think that in having reviewed thousands of declarations at this point, both our clients as well as opposing clients, I think that individuals who represent themselves as impropers, they really just focus on the one thing that they think that they're filing for, and they don't give enough detail to justify their request. And I know that we have that happen when we ask people to help provide the information for us to complete their declarations is that, as you stated, providing a historical account of what's actually occurred, explaining that breakup 3 years ago that we talked about in the past, what happened in those 3 years when they were working together, and then talking about this catalyst that says, okay, we have 3 different subsections of time that we need to talk about, because if you're the person who's giving a fair account of that historical timeline, then the judge is going to believe you because you're not trying to muddy the water when things were working well. And you're trying to focus on, look, we've always worked well together. Now we're having this disagreement. It doesn't mean that I dislike father or mother. I think that they're wonderful people, but we can't come to an agreement on this. And that's going to come over so much better with the judicial officer that you're in front of, rather than trying to say, I understand that we had this period of time where we did work together, but now I'm going to throw all of that away and say they were always terrible, because that's going to come off as disingenuous. It's going to say, well, what's different today that didn't exist 6 months ago, despite just one request? And so writing that really detailed historical declaration and your justification for what you want is exceedingly important. But I also think that you mentioned a really, really pivotal thing that not too many people actually even pay attention to. Why is completing your income statement to the court so important?
It's so important because, one, somebody could easily find out what you truly make by subpoenaing your work. So there's no point to lie there. 2, you don't want to look like you're living outside your means, because how are you going to provide for your child in certain aspects? As well as, how are you going to say, oh, I'm going to Disneyland, but in your income it shows that you can't afford that? Or for insurance purposes, you're saying you don't get it, but in your pay stubs, it shows you are.
Yeah, I think that not disclosing all of the things that are required on your income and expense declaration, which is Form FL-150, can be an absolutely damaging aspect to your family law case on so many different aspects. You touched upon not disclosing your health insurance information. If you don't disclose your health insurance information on your income and expense declaration, it's going to be impossible for the judge, opposing counsel, or even your own attorney to know to include it on your guideline calculation. It's important to be included on your guideline calculation because it is a part of the equation that gives you a fair amount to pay for child support. And your health insurance deduction is for yourself, your spouse, and your children. So it can be very, very damaging if you pay a large amount for your health insurance to not have it be a calculated aspect. What types of employees is it the most difficult to determine what they actually make on a month-to-month basis?
People who get overtime or compensation for certain aspects, because their monthly income is typically different month to month. So you don't know exactly how much they are making or if it's going to affect them in the future. I mean, we've had a client to where he had to work overtime to be able to pay his support payments, but he honestly couldn't even afford to have an apartment.
Yeah, those cases are very difficult because if your initial support order is calculated incorrectly, you do find yourself in that vicious cycle. Because if your regular base child support was calculated during a period of time where you worked an excessive amount of overtime that is not always guaranteed, you're then paying an excessive amount of child support over time. And as you said, you're working and working as much as you possibly can, but then you fall into this pitfall that says, you are now making even more than you were before, so now we're going to increase your overtime. And so really understanding how you get paid, what your base salary is, whether or not your bonuses are guaranteed, whether or not overtime is guaranteed, and whether or not there are other incentives that you get paid, and breaking them down into a regular child support payment or asking the court to defer from a guideline child support amount for your bonuses, incentives, and overtime, and doing what is called a Smith-Ostler. A Smith-Ostler is a amount that you're going to pay that's a percentage of all non-guaranteed income that can help individuals who receive excessively large bonuses one time a year that are not guaranteed, and you don't want to include in guaranteed child support. You can pay a percentage somewhere between 5 and 20%, depending on what those bonuses look like, can help people level out and live a monthly life because they only get that bonus, say, in the beginning of the year or at the end of the year, and then they can pay their one lump sum at that time rather than an excessively large one. What would you say is one of the difficult things when you receive an income and expense declaration from the opposing party who is self-employed? What are some of the things that you look for that could be maybe miscommunicated in the income and expense declaration?
Their monthly expenses, their amount of real property and personal property, their bank accounts, as well as what they say that they claim. And half the time they don't include what is needed, which is your profits and losses or 2 years of taxes.
Right. And so when you say that the profit and losses and the 2 years of taxes are required, where are you getting that from?
It's on the form itself on page 2 at the very top.
And the form that you're referring to is the FL 150, the income and expense declaration. Is that correct?
Correct.
Okay. And so according to page 2 of that form, if you own a business, you are required to provide your latest profit and loss. Is that correct?
Correct.
All right. And what about the tax returns? Who does that apply to?
I believe it actually applies to everybody, that it tells you that you need to provide those last 2 years.
And you are correct. The tax returns apply to every single person who is filing an income and expense declaration. However, one quick tip is that courts would actually prefer that you bring them with you to your upcoming hearing rather than filing them because you have to redact all of your personal information. So rather than having to do that, they would prefer that you just bring it to the next hearing so that you can verify your income. What is another thing that's required on page 2 if you own a rental property?
Oh, man. Do you have to provide the lease agreement?
You should provide the lease agreement, but it's, again, not the same as a profit and loss because the profit and loss actually is a required generated document that you use to be able to do corporate taxes or to show the profitability of your business. But when you actually own rental properties, they ask you for proof of all rental payments, as well as a breakdown in either a profit and loss and or an Excel spreadsheet on every single dollar that comes in and every single dollar that's spent on those rental properties. And so it's another pitfall for people who own these rental properties that don't really pay attention to them, but it can also become another issue. And I just had this recently happen on one of our cases where they're asked under penalty of perjury whether or not they are recording their rental income on their tax returns. So again, this is one of those pitfalls about cash payments that can also come up that can get you into some hot water, maybe with the IRS or the Franchise Tax Board, is that if you now have signed something under penalty of perjury and you are testifying about it, and you signed tax returns previously with your spouse, and you knew you guys were receiving this rental income and you didn't actually account for it on your taxes, you can walk yourself into that as some hot water. But more importantly, I want to talk about some of the cases that we've had where the owner of a business who also gets to dictate what they pay themselves every month. And that amount, let's say it's $7,000 per month. But on page 3 of the FL 150, we are seeing expenses that far exceed what they're making. How often would you say that we get income and expense declarations that look like that from business owners?
Quite often. I feel like Some business owners, it's not as often, but there would be a discrepancy in most of them with what they make and what they are actually spending per month in their household expenses.
Yes. I think that one of the largest problems with business owners and their income and expense declarations is that there are different rules for what is a write-off for taxation purposes and what needs to be added back in for your income for child and spousal support purposes. I think one of the largest things that people kind of double dip on is that they'll say that they are paying their health insurance. So it's one of the things that they want calculated into their child support, yet it is not coming out of their income. It is also not coming out of the flow-through income that's coming through the profit and loss and your taxes, because the business is paying for it before you've ever paid yourself and before you've ever taken a dividend. That in and of itself is going to look like perjury on the stand because you are not paying for it. So you shouldn't be able to take the deduction on your child support guideline calculation. And it is another benefit that needs to be added in to what your income truly is if you're going to get the deduction. So you need to be very clear on your income and expense declarations of whether or not it is not a part of your income because it's just a part of your total compensation package. And therefore, you're not asking for the write-off, but it is going to come in as income, or whether or not you are going to take it as the write-off for the guideline purposes, meaning that it's going to reduce your total amount of support to be paid or to receive, and then have it come off of your income. But you can't have it twice. You can't double dip. I actually heard you today while you were teaching some of our paralegals in the office about double dipping on your income and expense declaration. So what other types of double dipping, so to speak, should people listening want to avoid doing when they fill out their FL-150 and file it with the court?
Credit cards. People, a lot of the time, they'll use their credit cards to pay for their groceries or for clothes. And then on their monthly expenses, they'll say that they spent this much on clothes and this much on groceries, but really they used a credit card and then they're paying that monthly credit card bill down. So you're not actually spending what you said on groceries and clothes because you put it on the credit card and you're paying that credit.
And there's a specific section on the FL-150 that you have to write what you pay every month for your credit cards?
Correct. You have to say how much you make, what the balance of that credit card is, and when you last paid it, along with what that credit card is for.
So under that scenario, you either would want to say that you spend $500 on groceries and mark the box estimated expenses rather than your actual expenses, to say you know that you need $500 per month in groceries, but you can't afford to pay it with your income because you're using your credit card, which is going up every single month because you don't make enough money to pay all of your bills and your credit cards. Would it also be a fair statement to say that under the scenario that you gave previously, where you're not going to list it under clothes or food or whatever you're using it on? Maybe it's gas, maybe it's your insurance payments for your cars or your homeowner's insurance. Would it be a fair statement to say that it might be beneficial to just make an attachment to your income and expense declaration to explain what expenses you're actually paying for on the credit card so that it actually makes sense that your expenses outweigh what your actual income is every month?
Yes, it most definitely would. I know we had one client that their attachment was actually probably half a page just explaining all of their credit cards and what they're used for. And each one had a specific purpose.
Yes. So I think that when it comes to filing things with the court, over explaining is not actually a bad thing, especially if you are then going to use it for purposes of under penalty of perjury. You'd rather be over-explanatory than find yourself in a hiccup because you have double dipped or you have overinflated your proposed needs when you've never actually needed that much in the past. Another thing that I have seen is that when someone wholly under accounts for what they spend every month to justify what they're actually making. We had a case a very long time ago where it began as a custody and visitation case, wherein mom had custody of the child. Dad wanted custody of the child because mom had moved from the state of California to the state of Hawaii and then moved to the state of Florida. And dad didn't think that it was good for the child to be moving all around. The child wanted some more stability. Mom was making a big deal about it. Mom was using dad's inferior income as a reason to not give dad custody of the child. In that case, dad ultimately gets custody of the child because it's in the child's best interest to have stability. Mom, the opposing party in this case, says that she doesn't want to pay child support. We should just set it at 0. Well, of course, mom would say that because she's the high income earner. She had inherited a large real estate holding from her parents, and she had consistently given us inaccurate information on her income and expense declaration. And we knew this to be true because her social media platforms, her children, as well as the subject child, had gone on yacht parties. They had chartered boats out of Florida. They flew first class. They were paying the full-time tuition for 2 different college students at the time. And so when we found ourselves in this situation where we knew that they were outright lying, what is a mechanism that we can do? And you had stated that someone could get access to that. What do you do when you know someone is lying and there's going to be definitive proof that exists at a bank or even throughout their own admissions? What can you do in those situations?
Well, you mentioned admissions, so you could do a request for admissions. You can subpoena their bank records. You could ask for a demand for production of documents. So she did get inheritance. So you can demand to see a copy of that or prefer for them to provide a copy of that trust showing what they would get. There's multiple things.
And all of these mechanisms that you just referred to, what is the general understanding? What title do they fall under? All of those things that you just said.
Discovery.
Okay. So you definitely want to conduct discovery in every case where income is at issue, assets are at issue, debts are at issue, businesses are at issue. You want to conduct this discovery because you want the other side to answer your questions under penalty of perjury. Another discovery mechanism that exists is you can do a demand for inspection. This is what you use in cases where you need to do an appraisal of the home and the opposing side keeps turning away your appraiser and they will not allow for them to go inside the home. You can also do depositions. A deposition is basically, in my view, a trial run of what their testimony is going to look like at the time of trial. It's also your opportunity to get them to trip up their answers either at the deposition or at trial, and then you can use that trip up or blatant lie to thwart their credibility. So under these circumstances, like you said, doing requests for production of documents, requests for admissions, form interrogatories, special interrogatories, all of these things allow for you to gain access to information to prove a document that is signed under penalty of perjury that it's incorrect. And I think that this is a underutilized mechanism in family law, especially for those that call our office and say adamantly they know that someone's lying. If they don't hire an attorney and they know that the other side is lying because they're gambling all the time, they just bought a brand new car, they got qualified for a home loan, or they just got into a new rental that is for $6,000 per month, or they just got a new credit card because the new credit card was listed on their income and expense declaration and they're saying that they're unemployed, but it's carrying a balance of $30,000. All of these applications, your rental application, your mortgage application, your credit card application, someone has to specifically state what their yearly annual income is. You can subpoena those documents, you can request those documents, and you can basically pigeonhole people into admitting that they're lying, which is going to ultimately help your case. So I think that one of the most underutilized things for pro pers is the discovery process because they simply just don't know how to do it or how to use the information that they have at the time of trial to prove that the other side is lying. So I cannot stress this enough, and I think that you've stressed this as well today, that your income and expense declaration is probably the largest pitfall, aside from disparaging the other parent in mediation in recommending counties, which are San Bernardino and Riverside, because when you sign something under penalty of perjury, and you can be proven to be blatantly wrong, your credibility is out the window. And so when you're filling out this document, and I know from our own clients, they're not really paying attention to those monthly amounts. They're not paying attention to how they're changing throughout the month. I know from my own life that I don't spend exactly the same amount month in and month out, especially if I've gone on vacation or if there was something that needed to be maintained on my car, or God forbid I buy something new. Every month is going to be different, yet everyone's going to continue to give you these average numbers, but they need to be correct, especially before a hearing or a trial. And so I think that's one of the big takeaways that I want them to know. But if you could have another takeaway from family law in general, and aside from your FL 150 discovery and preparation for mediation, what is one other thing that you think is exceedingly important for people to know?
To be honest with your attorney. But to really just make sure that you are being true to yourself when you're saying these, when you're doing what needs to be done, as well as being true to your children. Because in the end, they're the ones that are affected the most.
Yes, I would definitely say that before you go forward with a request, that you need to have the hard conversation with yourself, that one, you're doing this for the right reason, which, as you stated, is your children, but two, that you're actually pursuing something that you want. One of the things that is kind of a joke in the family law attorney realm is that the person who is going through a fight with their spouse and threatens the divorce, but then only files for legal separation, will inevitably be slapped with a response for a dissolution, despite the spouse who filed for the legal separation never really wanting to get divorced. It was all really a threat. But everyone should know that California is, one, a no-fault state, and two, only requires one person in the marriage to have a marriage get pushed through for dissolution. So I think that that anecdote is really parallel to what you said. I think too often people act on emotion. They act reactively and they say, this is what I want to do. I want to do this. I want you to go after them as a pit bull. I want you to hit them with everything that you have. Let's send them with discovery. Let's do X, Y, and Z. And then when clearer heads prevail, they see that they might have gotten themselves into a situation that, one, is costing them too much money, but two, really isn't the route that they wanted to go in. So I think that that's a really, really great tidbit of information that people should know. Don't put something in a court paper, especially a request for a court order, if it's not what you want. You need to be true to yourself. You need to make sure that it's in your child's best interest and that you're not just doing this because you're mad today and you're going to change your mind tomorrow. So as a closing quote, I think that we're going to go off of your last tidbit is that you have to be honest with your attorney. Your attorney cannot protect you if they don't have all of the information. You don't want your client to be blindsided at the time of trial. You especially don't want your attorney to be blindsided while you're on the stand. Your attorney cannot protect you if you aren't honest with them. I don't care what the bad information is. It is better to be upfront with that information so that we can work around it. So, pitfalls to avoid. Don't make disparaging comments about your spouse or ex in mediation.
Correct.
What's the next one?
Being truthful on your income and expense declaration.
Yes. Making sure that your expenses match what they are each month so that you don't actually get into a predicament on the stand wherein they can prove that you don't actually spend $500 every month on clothes and therefore you need much less than that, or that you're double dipping.
Correct. And then being truthful to your attorney.
Yes. Always be truthful to your attorney. Make sure you don't sign anything under penalty of perjury that you know to be knowingly false. Also, because this has happened to us in the past, do not provide falsified documents to your attorney and ask them to file them on your behalf.
I will find out.
This is very true. And make sure that you prep yourself before mediation so that you know how to make those statements non-disparaging and child-centric. I want to thank you so much for taking time out of our very, very busy work week to come here and have this chat with me. I think that it is absolutely informative for anyone out there going through the family law process to know these specific pitfalls. And I think that with your 8 years in our office, that you've seen a lot of them.
Thank you for having me. I enjoyed it. I was very nervous, so I apologize ahead of time.
Well, thank you.
You're welcome.
Not what you want. You need to be true to yourself. You need to make sure that it's in your child's best interest and that you're not just doing this because you're mad today and you're going to change your mind tomorrow. So as a closing quote, I think that we're going to go off of your last tidbit is that you have to be honest with your attorney. Your attorney cannot protect you if they don't have all of the information. You don't want your client to be blindsided at the time of trial. You especially don't want your attorney to be blindsided while you're on the stand. Your attorney cannot protect you if you aren't honest with them. I don't care what the bad information is, it is better to be upfront with that information so that we can work around it. So, pitfalls to avoid. Don't make disparaging comments about your spouse or ex in mediation.
Correct.
What's the next one?
Being truthful on your income and expense declaration.
Yes. Making sure that your expenses match what they are each month so that you don't actually get into a predicament on the stand wherein they can prove that you don't actually spend $500 every month on clothes and therefore you need much less than that, or that you're double dipping.
Correct. And then being truthful to your attorney.
Yes. Always be truthful to your attorney. Make sure you don't sign anything under penalty of perjury that you know to be knowingly false. Also, because this has happened to us in the past, do not provide falsified documents to your attorney and ask them to file them on your behalf.
I will find out.
This is very true. And make sure that you prep yourself before mediation so that you know how to make those statements non-disparaging and child-centric. I want to thank you so much for taking time out of our very, very busy work week to come here and have this chat with me. I think that it is absolutely informative for anyone out there going through the family law process to know these specific pitfalls. And I think that with your 8 years in our office, that you've seen a lot of them.
Thank you for having me. I enjoyed it. I was very nervous, so I apologize ahead of time.
Well, thank you.
You're welcome.